Hi, this is Stuart Solwin, and I'm a criminal defense attorney here in Scottsdale, Arizona. And in this video, we're going to talk about the crime of threatening or intimidating. This is a common crime that I see charged a lot, especially in the city courts. And these are often also charged as domestic violence offenses. They can be charged as either a misdemeanor or a felony as well, depending on the circumstances. So let's dive right into discussing this crime. The criminal law that defines the crime of threatening or intimidating is ARS 13-1202. Under this law, there are three different ways that threatening and intimidating can be charged. The first is under subsection A1, which says that a person commits this crime if the person threatens or intimidates by word or conduct to cause physical injury to another person or serious damage to their property. Okay, so what does this mean? Well, the most straightforward example of this would be if a person makes a credible threat to hurt somebody else. The second way that the crime can be charged is under subsection A2, which occurs if a person makes threats that cause serious public inconvenience, such as the evacuation of a public building. This would be, for example, if a person calls in a bomb threat that leads to an evacuation of a sports stadium. The third way is discussed in subsection A3, which occurs when a person makes a threat in order to promote the interest of a criminal street gang. So, for example, if a person is in a gang and threatens to commit violence on behalf of that gang, then that type of threat would fall under this subcategory of the statute. Let's talk about the penalties for this crime. Subsection A1 as well as subsection A2 are both defined as Class 1 misdemeanors. This means that the maximum penalty you could be facing for misdemeanor threatening and intimidating is up to 6 months in jail, as well as $2,500 in fines along with probation, possibly also community service and classes that you'd need to take. Threatening and intimidating under subsection A3, which is the one that involves threats of gang activity, that is a Class 3 felony. So now let's talk about what else can happen if you're charged with threatening or intimidating. Well, for the purposes of this video, I'm just going to focus on subsection A1, which is the standard misdemeanor threatening or intimidating, where a person threatens to hurt somebody else or damage their property. And the reason I'm doing this is because this is the one I see clients facing the most often. And if you're watching this video, it might be the crime that you're facing. So in cases where I've represented clients faced with this type of threatening or intimidating charge, the results are often much different than the maximum punishment of 6 months in jail. I often see results where a person's given probation with no jail time, or where the case is dismissed entirely, although every case is going to be different. My view is that when you approach charges like this, you want to negotiate with the prosecution from a position of strength. So if I were to get a client who is facing these charges, the first thing I'd want to do is conduct a defense investigation, interview any witnesses that there are to interview, and file motions with the prosecution to get all the evidence that the state has. This can include not only things like the police report, but also things like body camera footage that the officers have on them, 911 calls, and other records from the date of the incident. One of the big questions that we're looking at when we investigate a threatening and intimidating case is whether the state can prove their case beyond a reasonable doubt, which is the standard of proof in criminal cases. And we often have to look at the alleged threatening statement very closely and determine whether this was considered a true threat. And here's what I mean by that. Under the Arizona criminal law, a true threat is where the person who hears the statement would take it as a serious expression of intention to inflict bodily harm. So we have to look at whether a reasonable person would take the statements in the supposed threat seriously. Now, we all know that when we're talking to people, context matters a lot. And sometimes the police investigation might take statements out of context. A statement by itself if you're just looking at the transcript, it might sound threatening, but if you look at all the surrounding circumstances of how the statement was made and who made the statement, it might not be something that really should be taken seriously. So let's take an extreme example of this. Let's say that you have two friends and they're arguing, and one of the friends says to the other, "I'm going to call up Mike Tyson and have him beat you up." Okay, well, look, on the face of it, that is a threat of violence. Mike Tyson is a formidable person. He could certainly, if he came over, beat me up. That could be scary if you took it seriously. But then you have to look at the case and say, okay, well, would anybody really take this seriously? You know, the friend might say, "Look, I've known you for 10 years, buddy. You've never once said you knew Mike Tyson. And then even if you called him up, who's to say that he'd come and beat me up," right? It's just, you look at that statement and a reasonable person would say, okay, that's not really a true threat that somebody would take seriously. So it shouldn't be charged as threatening or intimidating. Now, a lot of cases are going to be more complex than this, but the point is, you have to look hard at the context of the statements to see whether they're really threats or not. And a lot of what we do in these type of cases is to show to the prosecutor or to the court that the statements made just don't fall under this category of being a true threat. Now, in addition to the true threat defense, there's also other defenses as well. There could be free speech issues involved. Self-defense might be an issue, or the person making the accusation against you might simply be lying, and the case is a he said, she said about what happened, which isn't usually going to be a very strong case for the state. So there's a lot of different defenses that can be brought up, and we can't go over all of them in this video and all the different permutations, but what I recommend is that if you are facing threatening or intimidating charges, is to call up a defense attorney and see what defenses might be available in your case. My firm offers free consultations on criminal cases, and if you've been charged with a crime, we'd be happy to talk with you about it. So give us a call if that's the case. Otherwise, I hope that this video has been informative, and I'll see you in the next one.